the member of this court that requested for a subpoena to direct questions to this witness.
We submit, Your Honor.
All right. So, the gentleman from Iloilo may now proceed to ask questions from the witness.
Thank you, Mr. President. Madam Witness, the Senate President during the last hearing asked you to produce the monthly statements of the peso account of the Chief Justice Corona from 2005 up to 2010. It will be recalled that counsel for the respondent, the Chief Justice Corona, manifested before this court that he was willing to go to the offices of your bank and examine these documents. And it is at this point that we ask that this court be allowed to share and be notified and be informed of this document. Do you have these documents with you?
If Your Honor, please, if I intervene, Your Honor, and object, I will be ruled out of order.
Yes, what is the pleasure?
So I just want to make a manifestation, Your Honor.
Go ahead.
There was no statement made by us that we are willing to reveal all these things, Your Honor. We were asking for the breakdown of that deposit because we feel that this being a current account, there are monthly statements, Your Honor. And the reason for that is we have not conferred in so far as this matter is concerned with Chief Justice Corona. But after he assured us that we have these documents with us, we find no necessity to go over the documents in possession of the bank, Your Honor. In fact, we have filed a manifestation, which we filed on February 13, Your Honor.
Correct. That is my also the understanding of this chair, that we were talking about this specific bank account and the monthly bank reports for the depositor from 2005, I think,
yes,
it was, all the way to 2010.
That's correct.
And only the running balance of this account. If you remember, we were talking about an ending balance as of 2010 of 12 million pesos, I think, if I remember correctly.
14 million something, Your Honor.
Anyway, whatever it is. And then I said, this is a current account, and it was opened in 1989, and I asked whether the ending balance, whatever it was, whatever that amount was, whether it was 12 million or 14 million, is a sum total of all the transactions, deposits, and withdrawals over that long period of time. And I was corrected by the counsel for the defense when he said that only from 2005 up to 2010.
That's correct, Your Honor.
So that is the situation.
Yes, Your Honor.
It did not call for any other documents outside of those monthly balances for the operation of that current account.
Yes, Your Honor.
Okay.
This was brought about by our cross-examination, Your Honor, and it was what we were trying to clarify is what makes up the alleged 14 million deposit, whether it was one single transaction or various transactions. And in considering that up to that time there was no assurance on the part of the Chief Justice that we have the necessary documents with us, we made the request. But finding out that we have the necessary documents, Your Honor, to explain or further this amount of 14 million, Your Honor, we have chosen to withdraw.
And in
And
fact,
we cannot be compelled by I'm sorry, Your Honor.
Good.
And we cannot be compelled by the prosecution, much less by a single senator judge to do whatever is not in accordance with our postulation or articulation, Your Honor.
By the way, this is started when the Defense Council agreed about the submission of the monthly statements for this particular current account of the respondent. And I even suggested that both the prosecution and the defense ought to go to the bank themselves to expedite the proceeding to look at those bank accounts. But later on, the defense counsel said they have some of the records in the possession of the depositor, and who is actually the respondent in this case. And that is where some discussion again ensued. That is the recollection of the chair.
That's correct, Your Honor.
Your Honor, please.
But
Your
may
Honor.
I be able to read into the record, Your Honor, what precipitated that particular issue by way of discussing the same, Your Honor?
Proceed.
I am referring to the minutes of the proceedings of Thursday, February 9, 2012, Your Honor, transcript. This is, presiding officer, this is a simple problem. Let them decide who is going to confer with the very able defense counsel. So you want to deal with the head of the panel. I think since they have control over their panel and their defense counsel, they can designate whoever they want to go with the defense counsel to examine the records. Mr. Cuevas, this is my point, Your Honor. Your Honor, please. Presiding officer, yes, Justice Cuevas. While the court is debating among its members the matter of inspection or production of the statement of accounts, Your Honor, my co-counsel in the defense received a call from Chief Justice that he has these documents, Your Honor. Some of these documents I'm referring to, the statement of accounts are with him. I would not know which will be material to us. If this is true, then in effect we are withdrawing the motion because we have them already with us. That is my point, Your Honor. We will not unduly burden our colleagues, Your Honor. That is the end of the discussion, Your Honor. We cannot be dictated upon. I beg permission of the court, Your Honor, by stating this on record, on how we should handle the defense for our client. That is our sole responsibility to our client, Your Honor. Neither the prosecution can tell us what to do, because we are not under the control or supervision of the prosecution.
Your Honor, please, may the prosecution...
Let the defense speak first.
Sorry,
I'm not bright enough to have all of you talking at the same time.
My apologies, Your Honor.
Then the presiding officer, then why can you not talk to your client and then communicate with Mr. Cuevas? We will do that, Your Honor. Precisely that is why we are asking up to Monday, Your Honor. Presiding officer, let it be Monday. Thank you, Your Honor. That was the end of the discussion insofar as the statement of accounts are concerned. Why will be compelled to go to the bank and examine this when we have the documents that we wanted to present, Your Honor?
Right. Are you true?
Yes, Your Honor.
All
Thank
right.
you very much for the
The
opportunity.
prosecution.
Thank you very much, Your Honor. My apologies once again for the...
No, don't apologize
interruption.
anymore. No more pasicalles. But just go direct to the point.
Your Honor, with due respect to the defense counsel, what he has stated are not in accordance with the record. The record of February 9, 2012 will bear out that there are now 3 sets of documents. The first set of documents were those required to be produced in the subpoena of February 6, 2012, which this humble representation elicited from the witness. And after completing the testimony, indeed, I confirm now that I stated that is all for the direct, and Justice Cuevas started on his cross. Unfortunately for the defense, during their cross-examination, they themselves went into the matter of monthly statements, which were not in the subpoena, but motu proprio of their own volition, they went into monthly statements.
That's correct.
Yes, Your Honor. And then, there was that agreement initially for both sides to go to the bank when I withdrew my opposition that he will go there by his lonesome. And then the Honorable Presiding Officer was judicious enough to suggest, why don't the two sides go together?
Up to that point, correct.
Yes, Your Honor. And so, there was that subsequent manifestation by the defense counsel that, after all, they were interrupted in their strategy for cross by their own client who said, do not go to the bank with the other counsel. I have the statements here in my possession. And so he appeared to have withdrawn the motion. But then there was again a caveat. We will still clarify with the Chief Justice. Give us up to Monday whether we will really withdraw the motion to go there together or not. And then Monday afternoon, they filed a manifestation. They realized perhaps their mistake. They now do not wish to go to the bank. That's the first point. Second point, Your Honor, is that is the first set of documents. The second set of documents now are those set of documents allowed already by the Honorable Impeachment Court through the Honorable Presiding Officer to be brought before this august body by this same witness as requested by Senator Drilon. And
That is a separate matter altogether.
Yes, and this is found on page 70.
That is not your concern. That's the concern of a judge of this court.
It is my humble submission, Your Honor, please, if you will please kindly allow.
Go ahead.
That in the same manner that the defense counsel would not wish to be dictated upon in their prosecution or defense of their client, in their defense of their client, the prosecution would also want to see to it that the search for truth is not hampered by technicalities. They themselves opened the matter about monthly statements. Senator Drilon merely pursued it, and Senator Drilon requested those monthly statements to be brought here, and the Honorable Presiding Officer allowed that.
Let Senator, the judge of this court, deal with that matter.
Yes, Your Honor.
You have finished your direct examination of this witness.
Yes, Your
The
Honor.
only issue was whether you go to the bank to examine the monthly statements, or they will produce the monthly statements, and if you are not satisfied about the authenticity or accuracy or integrity of those bank statements, that will be a matter that can be decided again by this court. All right?
Just a final manifestation. I was merely discharging my duties to Your Honor.
I know that.
As an officer of the court, to assist the court in keeping track of the proceedings. In fact, I will end, Your Honor, with a last manifestation that there is a third set of documents, those requested by the Honorable Gentleman from Cebu, which the Honorable Presiding Officer also allowed. Thank you, Your Honor.
We are quite aware of this, even if we are 88 years old. I assure